Thank you so much for joining us today. I am Kelly Ransford. I am Deputy Administrator and General Counsel here at the Department of Consumer Affairs. And education is a core component of our mission here at the department. So today we are talking about the recent changes to the closing fee statute. We're kind of learning this all together. So we will get started on what has changed. As always, the legal disclaimer. I am an attorney, so we have to do this. This presentation is not meant to serve as a substitute for reading the various laws discussed, seeking legal counsel, or otherwise requesting department guidance and/or interpretations on the laws it administers and enforces. The presentation merely serves as an introduction and overview to what we're going to talk about today. As I said, we're talking about Act 45 from this session. It became effective on May 16th, 2023, and the act was intended to, it relates to motor vehicle closing fees and requires the closing fee to be prominently displayed with the advertised price, to require the fee to be reasonable, and to specify the manner in which the Department of Consumer Affairs is able to provide enforcement measures. We've got a link down here at the bottom that shows you it's the tracked changes version, so you can see what was struck through and what was added with underline, and that's available on the State House website as well. All right, here's our roadmap for today. We're going to talk about the filing process, what's changed, what hasn't changed. We're going to talk about perpetual certificates, disclosure requirements, the department's access to records, and reviews and investigations done by the department. So first, we're going to focus on one thing that did not change, and it's a pretty important one, the $225 amount. So it's still the dollar amount that if you charge $225 or less, there is no reasonableness review. You merely file a closing fee notice with our department and you pay your filing fee. If it's over $225, that's where the department may review for reasonableness. You would file your closing fee notice, the addendum and supporting documentation, and pay the filing fee. Some of the requirements associated with the reasonableness review have changed, so the department has updated our forms, our online licensing system, and our processes. So we're going to go through those changes now. This is one of the first changes you'll notice is that a dealer's costs must be calculated using generally accepted cost accounting principles for the preceding 12-month period. This is new in the law. This was not required in the old law. So we have updated our addendum form for the over 225 filings, and we provided a place for the responsible person to attest that the dealer costs and supporting financial documentation were in fact calculated using generally accepted accounting principles for the preceding 12-month period. So this is not the office manager or somebody who maybe does your files your application. This is someone who actually, either supervised or performed the gap analysis and did the calculations themselves. In determining reasonableness, the law provides that the department shall accept and allow the dealer's actual costs and expenses, including but not limited to employee compensation, information processing, facilities costs, supplies, and materials associated with closing and delivery activities. And those activities we're going to go over on the next slide. So you probably recall, if you've done the addendum before, that the old law provided 5 categories. In the new law, some of these categories have been tweaked. So we have, the department has updated the addendum to reflect the new categories. The old law provided for costs associated with closing the transaction. The new law specifies that this includes the associated loan or lease, and also transferring the title to the consumer. The second category is delivering the vehicle to the consumer, and this is new. So you can see here the things that were in the old law, we've got in black text, and then the things that are new or have changed somewhat are going to be in kind of the teal blue text. The third category is complying with state, federal, and lender requirements, and this was in the old law. The fourth category is preparing, storing, and retrieving transaction documents. So this was pretty much in the old law, but it was two different categories, and those have been combined here as category 4. And then finally, protecting private personal information of the consumer. And of course, that was in the old law as well. Also in the new law is a statement that when the department is determining reasonableness, they can compare a particular dealer's costs only with other similarly situated dealers. So we would envision that to be something like, dealers in the same geographic area or the same size dealership, maybe the type of car, that sort of thing. That was our practice in the past, and now that's been codified in the statute. Another change in the law is the time frame for the department to process closing fee applications. The department now has 15 days from a complete application to provide written notice of its intent to review. This was, I think, 30 days in the old law, and now it's down to 15 days. A complete application is the documents have been filed that were required, and also the dealer has paid the filing fee. So that's what we deem a complete application. And dealers will hear from the department within 15 days of receipt of a complete application, and that would either be a notice that the certificate has been issued, that the application was processed and the certificate was issued, or it would be a letter indicating the department intends to do a formal review. Another changed time frame is that the department has 30 days from a receipt of a complete application to issue a written order regarding any findings that the fee is not deemed reasonable. So we haven't issued an order denying a closing fee or a portion of a closing fee in the 7 years since the law was last amended. So I don't know that that's going to be an issue, but we will give you a decision one way or another, whether it's been processed or an order has been issued within that 30-day time frame. So at this point, I guess, let me see. I'll go ahead and talk about the perpetual certificates, and then I might check and see if we have some questions. So as you know, in the past, you had to renew, or dealers had to renew their closing fee certificates annually. That is no longer required under the law. The dealer only needs to file with us when the dealer wants to change the maximum fee that is shown on the closing fee certificate. So generally, we would expect that to be for an increase. Under the law currently, the fee is actually the maximum, so you have the ability to charge less under the current law or under the old law. So you wouldn't necessarily have to file to reduce that amount. So we would expect it to be if you intended to increase that amount that you wanted to show on your certificate and be able to charge. So we have modified our certificates to reflect an expiration date that I don't think I am planning to see at any point. I figure somebody 76 years from now can handle, changing that or fixing that. So we're just going to have it that way for right now. Maybe in the future when we make some other changes, we might just take that off. But I also want to point out that your current certificate, if a dealer has applied, if they applied in the most recent renewal and got a certificate that was good until January 31st, 2024, those certificates are still good, and dealers can apply for a perpetual certificate at any time. And once they get that one processed, their new expiration date would be 2099. All right, so let's go see if there are any questions. Okay, I'm having trouble. All right, so I will check back in a minute. All right. So that's the filing process and the perpetual certificates. Next, we're going to talk about disclosure requirements under the statute. So the first two disclosure requirements you're going to find familiar. They're pretty much the same as the old law. You still have to disclose, or dealers have to disclose the closing fee on a sale or lease contract. The clarification there was to add or lease. And the second one is to display the closing fee in the conspicuous location in the dealership. So conspicuous location, typically what we, how we describe that to dealers is that a consumer can see the closing fee during the negotiation process, and it's not a surprise when they get to the F&I office to close the deal. There are a variety of ways to do this. You can post it at a sales desk where the negotiations are happening. You can post it at the front desk where the consumers enter the dealership. Anything like that would be considered clear and conspicuous disclosure. And then this is new, so this one's big. Under the old law, dealers had to include the closing fee in the advertised price for a vehicle. That is no longer required under the law now. Under the new law, if a dealer advertises a specific vehicle, the dealer must disclose the closing fee amount in the advertisement. So if you advertise a particular vehicle for $35,000, you have to prominently disclose the closing fee amount that would be added to that $35,000, but you do not have to include the closing fee in the $35,000 amount. So you're still required to sell the car for the advertised price. You just don't have to include the closing fee in that price that you have posted on your advertisement. Okay, next is access to records. So the rest of what we're going to talk about is pretty brand new. So it's pretty much should just all be in green. But so the department's access to records. Department shall have access to a dealer's records, but only to the extent necessary to determine the dealer's compliance with the disclosure provisions we just talked about on the last slide, and also to confirm the accuracy of the dealer's cost and expense information that they provide in their addendum and supporting documentation. What didn't change is that the law still requires this information to be kept confidential and privileged from disclosure. Next, there is a pretty large section. So this is one that I would certainly recommend. I'd recommend that you review the entire new statute, but this is brand new. So we're going to go through this. It'll probably take a little bit longer than some of the other slides have. But this is about the department's ability to review and investigate complaints related to closing fees. So the department may review or investigate a complaint upon receipt of a complaint, or review and investigate a dealer upon receipt of a complaint or other credible evidence that the dealer has violated a provision of the closing fee statute or another statute in the Consumer Protection Code related to closing fees. So we're going to go through the new process for complaints that are related to closing fees. First, the department will provide a written notice to the dealer that we have received this complaint or other credible evidence of a potential violation. This written notice will be sent via certified mail to the dealer, and it will be sent by email address if we have an email address on file. The written notice from the department will include sufficient information to identify documents related to the potential violation. It will include a request only for information reasonably related to the alleged violation, and it will tell the dealer that they may provide a written response to the complaint. A dealer has 45 days from the date the written notice was received from the department via certified mail to provide a response. If the dealer fails to provide a response within 60 days of receiving written notice via certified mail, the department can commence a proceeding pursuant to the Administrative Procedures Act. So you see there, you've got the 45 days to respond, and it looks like the intent was to give maybe a 15-day grace period as well. So nothing would start until 60 days after the dealer has signed for the certified mail. If the department determines that the dealer failed to comply with the requirements of the closing fee statute or another statute in the Consumer Protection Code related to closing fees, then the department will issue a decision with, or I apologize, we'll issue a decision within 15 days of receiving the information. But if we determine that you did actually, the dealer actually failed to comply with the law, we will include in that determination whether the failure to comply or the violation was not intentional and resulted from bona fide error, or was indeed considered intentional. If the violation was not intentional and resulted from a bona fide error, the dealer must refund any excess charge paid by the consumer, and the department must close the investigation into that complaint or other credible evidence. If the violation is found to be intentional, the department may request only those records reasonably related to the alleged violation for the 10 transactions immediately preceding and the 10 transactions immediately following the transaction identified in the complaint or other credible evidence that's provided to the dealer. If the department discovers a potential violation of any kind related to closing fees in any of these transactions, the department may request only those records reasonably related to the alleged violation for transactions occurring on the date of the original transaction, 30 days before that transaction, and 30 days after that transaction. Under the statute, a dealer may not be held liable in any action for a violation of the closing fee statute or any other statute in the Consumer Protection Code related to closing fees if the dealer can show by a preponderance of the evidence that the violation was not intentional, and also it resulted from a bona fide error notwithstanding procedures reasonably adapted to avoid the error. And also, the dealer has refunded any excess charge paid by the consumer. So you can show that it's a bona fide error and not intentional, and then the dealer refunds the excess charge paid by the consumer, and the dealer will not be liable for that violation in any other action. If the department finds that a dealer has intentionally violated the closing fee statute or any other statute regarding closing fees, the dealer must refund the excess charge paid by the consumer within 30 days of notice from the department. You kind of see here that the common theme is if there is an actual violation of the closing fee statute or another Consumer Protection Code statute related to closing fees, the consumer has to receive a refund of the excess charges. And then next is the penalties associated with an intentional violation. So you'll probably recognize kind of the structure of this. It's similar to the advertising and enforcement provision. So we'll go through those. If it's a first violation within a 12-month period, then the department will issue a written warning notice to the dealer. For a second violation within a 12-month period, the department can assess a penalty of $500. For a third violation within a 12-month period, the department can assess an administrative penalty up to $1,000. And for a fourth and subsequent violation, the department can issue a penalty up to $5,000. But the cumulative penalties for a dealer to pay shall not exceed $100,000 in a 12-month period. Okay, so that's pretty quick. Let's see if we have any questions. Okay, it looks like, is there a fee to apply for a perpetual certificate if I have a current one that expires January 31, 2024? So you are not required to file right away. So you can still operate under the certificate you have now until 2024, January of 2024. You have the ability to file for the perpetual certificate at any point, and it would be the $25 fee. You would pay it once, and then by virtue of being a perpetual certificate, it would be the last time you'd have to pay. So yes, there would be one more fee to pay if your certificate currently expires 2024. And what is the process for filing for a perpetual certificate? Will it be like a normal filing? I'm going to say yes and no. So you still need to provide the supporting documents. Well, let me back up. If it's 225 or less, you just file the one filing form. You pay the fee. We'll process it within probably 24 to 48 hours, and you will get your perpetual certificate to charge that 225 or less, and you can post that immediately. If it is over 225, you still need to provide the same documentation as far as the filing fee form, the addendum with the breakdown for the 5 categories, the maximum amount you're seeking to charge, and then you will have to provide the supporting documentation to show that you've done that gap analysis or calculation, so that you've to be able to show that you have calculated your fee in accordance with the generally accepted cost accounting principles. And so that would be kind of the difference between old and new. If you typically do it with according to gap analysis, then that would be the same, or you may end up needing to modify your filing materials, your supporting documentation. And this question, I believe, is asking if we have perpetual certificates for maximum rate schedules. We do not. That the perpetual certificate is solely based on the closing fee statute. So it would only be for the closing fee dollar amount. Let's see. Oh, also I see we have a links. Okay, we've got some links in the chat feature. Links to, oh yes, a link to the strike-free version, the one where you can actually see the edits that were made. And then we also have a link to the closing fee filing page on our website. And that's where the new forms are located. We've also posted the law there under the law section, just for ease of reference. Okay, let's see. Does the closing fee need to be listed as a closing fee on paperwork? For example, buyer's order. We use admin fees. So we recommend, because of the way that this statute is set up, we recommend if it falls within that definition of a closing fee, if it's for the administrative work to close out the vehicle, we always recommend that you actually change your paperwork to say closing fee, and that way you're protected under the protections of the statute. That you just don't want there to be any confusion that you're charging something other than a closing fee. And there are certain civil liability protections in the statute for closing fees. So we would recommend that you amend that to say closing fee. Okay, so I have a question about whether closing fees are taxable, and I cannot recall off the top of my head. So we can get that answer for you. Trying to see. These are a little tricky, so it's hard to read them. If I understand correctly, if we file for the perpetual certificate and if we are approved for more than 225, we never have to file again. You don't have to file before 2,100. So that's the answer. You can charge us that fee for the next 76 years. What would be an example of an intentional dealer violation? Okay, so I kind of anticipated this, so I tried to come up with a way to describe it. It's kind of, it when you see it. An intentional violation would be something that looks like a pattern or practice. It's not a one-off. It's not, it would be something more like, a good example would be if you had filed for $500 and that was the maximum that you filed for, that's what your certificate says. And then you print off or you get the pre-printed contracts and all of them say $600. So that's going to be considered intentional. That's something that's not a simple clerical error. That's, something that should have been caught, essentially. That wouldn't be considered unintentional, therefore it would have to be intentional. So that would be an example of that. It's just something that's a pattern or practice. And just kind of along those lines, we'll go to what's not intentional. The statute talks about, if it's not intentional and resulted from a bona fide error. So it's kind of, you have to prove that it's both of those. You didn't do it intentionally, and also it resulted from a bona fide error, even though you have procedures in place to avoid that error happening. First thing to note, and this is pretty important, is you actually have to have procedures in place in order to show that that it is a bona fide error. And you have to, it's typically limited to clerical errors, like you mistyped something one time kind of thing, or you calculated something incorrectly. It's limited to that type of thing. It doesn't include a misinterpretation of the law or something to that effect. So hopefully that gives you a good idea of the distinction between the two. Let me see, I'm looking to see if I have more. Oh, it looks like some people know about the taxable. I've got somebody who says, I thought closing fees were taxable because we have to include closing fee with sale price in our Form 400 submitted to the DMV with registration. In that case, that does sound as if it is actually taxable. So thank you for volunteering that. If that is, I'm not familiar with that particular form, but if that is the case, then yes, that sounds like it would be taxable. Thank you so much. Okay. Still waiting to see if I have any other questions. And I just want to say, again, I said at the beginning, this is new to us as well. We appreciate everybody's patience as we work through implementing this new law. If you have any ideas or thoughts or questions, please feel free to reach out to us. I'm going to show you my my contact information in just a minute, but it's also all over the website. So feel free to just Google me, and I think it's everywhere. Let's see, I've got a couple of questions in here. Is there a specific form that will state that it is for the perpetual certificate? No, there's not a form. The form that is now on our website that was updated in June of 2023, that is the form that you want to use. And anyone that we get from now, or actually since May 16th, will qualify for the perpetual certificate or the the 2099 expiration date. So we've already got some out there. We had a handful come in already, and we already have some out there where we've issued the certificate with that 2099 expiration date. So you don't have to use a special form other than it is the form that is on our website, because we added that block about the attestation of the gap analysis. Let's see. Do you recommend having a CPA firm complete the application, or can the controller of the store prepare it? So the form itself is not what has to be prepared by the CPA. It's the analysis and the calculation that has to be done in order to substantiate the dollar amount that's in the form itself. So ideally, the CPA, if you have a CPA, do the calculation in accordance with the gap analysis. That they would sign off on that piece of paper, that attestation. But the controller doesn't actually have to do the analysis themselves. I hope if that answers your question. Let's see. There's a question about, let's see, power sport. I wonder, okay, there's something about power sport, MC, etc. Are now exempt from closing fee statute. I'm not sure I know what that is. If somebody. So we do have a notice on our website, and I'm not sure if this is what you're asking about as far as being exempt from the closing fee statute. We do have a notice on our website about how the closing fee statute, technically, the definition does not apply to motor vehicles. Motorcycles, new RVs, I believe. There might be another, But we've got that notice out on our website that that says, you know, if you sell motorcycles only, but you want to charge a closing fee, if you file a application with us, that we will process it. You know, but that it's not necessarily required if you don't fall under that definition. And also the new law specifically references the statute that we were relying on with the definition of a dealer in our notice that we issued that's on the website. So section 56-15-10, if you qualify as a motor vehicle dealer under that definition, I believe that's where the motor vehicle closing fee applies, the statute. Let's see, will you be making this information today so we can print this? Are you asking for a copy of the slides? If you're asking for a copy of the slides, we can definitely do that. We can issue that. Yes, okay, yes, that's what you wanted. All right, so yes, we will issue these slides, yes. And then what date do we need to apply for the perpetual certificate? The only required date would be January 31st of 2024. So you can do it any time between now and then. Just make sure to get it done by January 31st. Okay. All right. I'm not seeing any other questions. All right, so I will go, let me go ahead and show you a couple of things, just so you can see we've got, obviously we're, you know, on all the social media, so I'm not a big social media person, but feel free to follow us, like us, you know, whatever you do on social media. Also, we have publications that we issue, and we have our auto dealer guide that was updated last February that's available on our website. But we have all of these others that may be helpful to you as a consumer, if nothing else. Or you can have them available for your customers, depending on what you would like to do. But you feel free to get, we do packets of 50 that we'll mail you if you just let us know that you want them. So we'll do that. Just let us know. We have a button on our website, I think, where you can order those. And then, like I said, here's my contact information. If you want to reach out to me, we also have a legal division mailbox that is monitored by several people, legal@scconsumer.gov. So feel free to email that one and or email me directly, either way. Okay. I'm looking to see if I have any, because I'm done with the presentation. I'm just checking to make sure I'm not missing any more questions. I don't know if I missed it, but is the closing fee taxable? My understanding is that it is taxable. So, but you may want to check that it's not. Okay. All right. Well, thank you all so much for joining us today. Again, please feel free to let us know if you have any thoughts or ideas or questions. And I appreciate you being patient as we kind of work through this and figure it all out. And okay, I don't see any more questions, so we're good to go. Thank you, y'all. Only 35 minutes, so everybody have a great rest of your day. Thank you.